To conclude our works, I'd first say that the papers we've heard these past 2 days have shown a slow construction, in fact, of our 3 centuries of political norms based on principle of natural rights, a process which was marked by revolutions in the 17th and 18th centuries. And to conclude this workshop, I'd like to talk about the end of this cycle, which has marked the modern Western area. As you know, this cycle, as Suzanne said yesterday, this cycle began in the 16th century with the question of the humanity of Native Americans, a crucial political question which, as Brian Terney explains, brought natural rights out of the rhetorical jail in which scholasticism had confined and devitalized them. And this cycle came to an end at the end of the 18th century with what Florence Gautier has called the death of natural law in revolution. That's to say, the end of the principles of natural law considered as political norms, norms such as they had been set during the French Revolution by the Declaration of Natural Rights of Men and Citizens of 1789 and 1783, the moment that Gautier calls the triomphe of natural law in revolution. As we understand, in 1795, the Convention adopted a Declaration of Rights of Man in Society, and no longer of man, of natural rights of man. And then, in 1799, following Bonaparte's coup d'etat, it is the Declaration of Rights itself that disappeared. But reference to natural rights still being present in some discourses that justify institutions, while the political constitution of society has ousted natural rights, is not the case for its legal constitution in terms of private law. Natural rights were in fact put forward by the designers of the Civil Code, and in particular by one of them, Portalis. So natural rights were both deemed necessary to the legal refoundation of France, and at the same time ousted from the political organization. And to illustrate this tension, I start with a remark of Portalis made about an anonymous work criticizing the draft Civil Code. It's the quote: "The author of the pamphlet has heard that one becomes an anarchist if one intends to submit only to reason, and if one respects only that it please some philosopher to call nature. He needs no more. As soon as he encounters in the preliminary discourse or in the draft code the words natural law, universal reason, it's anarchy. Under his pain, the drafters are nothing but Robespierrists." That's rather present to see Portalis, a monarchist, jailed during the revolutionary government, compared with Robespierre. So, what's the link between the two, Robespierre and Portalis?
They both wear wigs.
Yes, exactly. This extract reminds us that during the French Revolution, natural rights were often associated with Robespierre. And then and that since 1795, through Robespierre, natural rights have been associated with the terror. One of the main manifestations of the terror for those who denounce it was anarchy. We find this discourse among the conventionals in the Meridionale period who opposed a declaration of natural rights in 1795. And outside the convention, the same line was taken by Jeremy Bentham, for instance, then living in France. And he's famous for his nonsense upon stilts. Bentham considered that natural rights are anarchist fallacies, and so they are a nonsense upon stilts. Bentham pointed out that Article 2 of the Declaration of 1789 is the language of terror. An article which states, as I mentioned, and as you mentioned it, I think too, earlier, that object of every political association is the preservation of the natural and imprescriptible rights of men. This is the language of terror for Bentham at this moment, and the same for the Thermidorians. Already during his lifetime, but especially after his execution, Robespierre was accused of having held, I quote, a share of natural law. In other words, of having been a professor instead of a politician, of being locked in abstraction and incapable of grasping reality. The terror would thus be the manifestation of Robespierre's disembodied dogmatism. Its main function would be to conform with guillotine real humanity to an abstract ideal type in order to create a new, pure, and virtuous man. In 1785, a famous pamphlet characterized the terror as a moment when, I quote, John Locke's metaphysical tabula rasa was put into practice. Locke in the book, it's good, but the practice, as we said frequently, is the main point. At the same time, Girondin, like Riouf, considered that abstraction lead to monstrosity. It thus explained that Robespierre and Saint-Just, drunk with imagination and pride, with no knowledge of men and things, living in an atmosphere of systematic illusion, had started in very good faith from a philosophical and legislative point, but they arrived, without realizing it, at the height of ferocity and barbarism. The principle of natural law thus necessarily engender the blood of terror. So in this discourse, the principles that are supposed to found freedom are in fact liberticidal. It is for this reason that the designer of the 1795 declaration, that I quote Saint-Just, say that we are carefully banished all those anarchist axioms collected in the tyranny, by the tyranny to that wanted to upset everything in order enslave everything. We banish all anarchic axioms. All reference to natural law, all reference to natural rights disappeared in 1795. There was to be no recognition of a system of law above the positive law, in the name of which positive law could be legitimately challenged. The Declaration defines a right as those, as we say, those of man in society. They are the attribute of a particular society and no longer inherent to the quality of human being that made them inalienable and universal. The reason why the article stipulates that all men are born, as Laura says, all men are born in the state of nature and remain free and equal in rights in the state of society, does not appear in the Declaration of 1795. In general, anything that might remind the nature of popular sovereignty or undermine the authority of a government is no longer included in the 1795 Declaration because it's anarchy. And as I mentioned earlier, Bonaparte went further and settled the issue by eliminating the Declaration of Rights of Man and of the Citizen from the institution. The political movement will no longer use the text of the Declaration to claim its rights in the name of the law. Natural law was excluded from political norms, excluded from public law, because it was deemed subversive in the wake of the revolutionary experience. But natural law is still used in private law, for instance, to justify the civil code's provision on family law, on marriage, on divorce. In particular, the code drafters needed a reference to natural law to justify property, as defined by Article 544 of the Civil Code. That is to say, I quote, the right to enjoy and dispose of things in the most absolute manner. And for Portalis, in his preliminary discourse in the Civil Code, possessing an absolute right over things originated in natural law. I quote it on the screen. Man is born with needs. He must be able to feed and clothe himself. He is therefore entitled to the things necessary for his subsistences and upkeep. This is the origin of the right to property. And for Portalis, this origin of the right to property establishes that it is appropriation in general and not just ownership of the things necessary for my subsistence. That is appropriation in general, that is natural right. Portalis does write that the right of ownership is itself, and therefore a direct institution of nature, and the matter in which it is exercised an accessory, a development, a consequence of the right itself. In 1789, this was the same, meaning that the majority of the Assembly had given to the Declaration of Rights, according that which property is a natural right. This enabled to implement a liberal economic policy. Owner must be free to use their property, and any hindrance is a violation of the social pact founded on man's natural rights. And this interpretation of the Declaration and the policy it enabled were at this moment profoundly contested by the popular movement and its representative, the Montagnards, for instance, and one of them, Robespierre. For the popular movement and the Montagnards, a distinction must be made between the right to existence, which included ownership of the things that enable me to live, with it, which is a natural right, and the right to property, a right that depends on each society, and that is limited by the natural right to existence. This view prevailed during the revolutionary government and was defeated in 1795. It's important to note that while references to natural rights are frequent in Portalis' preliminary speech to the Civil Code, they are no longer present in the Civil Code itself. Indeed, the preliminary speech to the Civil Code does not set out the ideas contained in the code, but the idea that Portalis would have liked to see in the code. Portalis referred to natural rights in the preliminary discourse for the sake of legal consistency. It's his work. But when he introduced these references to natural rights in the Civil Code itself, they was eliminated in committee, eliminated by the Conseil d'État, because this reference to natural rights risked reintroducing what was intended to be avoided, that is to say, anything that might appear political or compete with positive law. We can see this with the question of contracts. Question of contract, which is in the Civil Code, concern marriage and also concern companies. Portalis considers that contract belongs to natural law. In his report on divorce, he explained that the first duty of any person who commits himself is to observe the pacts he had made and to be faithful to the faith he has promised. And he had, the quote on the screen, and he had bodies of nations, governments are no less bound by their contract than individual, because the principle of human faith, which are of natural law, must be and are inviolable for all men. Starting from natural law, a question of private law, marriage contract or partnership contract, thus brings out a question of public law, that is to say, government contracts enshrined in natural law, which must be avoided since 1795. This article that Portalis has proposed on a partnership contract, therefore, disappeared in committee. This article was worded as follow. I quote: the partnership contract is governed by natural law and by the agreement of the parties. Beyond this, the entire preliminary book at the end of the code was emptied of its reference to natural rights. In particular, Article 2, which starts as, I quote, the rules prescribed by natural reason from natural law. These rules are the basic of all writing laws, which must only present more or less direct consequences of the principle of natural equity. Appeal courts, whose opinion was sought on the draft of the Civil Code, and in particular the Appeal Court of the Tribunal of Lyon, were the first to react against natural rights in this preliminary book, was in first at the head of the Civil Code. The Tribunal de Lyon wrote, I quote, all the maxims contained in the preliminary book, wrote by Portalis, even the least disputed, are certainly metaphysical legal abstraction, essentially subject, like everything metaphysical, to controversy, discussion, and interpretation. It may be useful for publishers to develop them, for legislators to meditate on them, but it is very dangerous to set them up as principle and to keep them in a code. For Portalis, it is through private order, legitimized by argument of natural law, that public order is instituted. The owner, the husband, the father, the boss become the keystone of the legislative system. But this private order, because it is fundamentally political, must be cut off from natural law at the Constitution. Legitimation by natural law, why it may be in the mind of the legislator, can never appear in the law, in the book, but not in practice. As the Thermidorian said in 1795, principle should be left in the book, where they will not incite civil war. Does the civil code mark the end, in fact, of the agony of natural law that began in 1795? As we know, it is a long time after, with the resistance to Nazism, that will bring natural rights back in life, with perhaps, I think, and we are in it, the opening of a new cycle. So, to conclude, on behalf of the organizer, I would like to thank everybody, to thank all the participants for the quality of their work and the quality of the discussion. A beginning, perhaps, of discussion, because all must be built, I think, on this problematics.